Welcome to this presentation. Today we're going to be covering the fourth part of Chapter 10. Of course, Chapter 10 is the chapter in which we cover discovery. And the topic that we're going to be addressing in this video are going to be requests for production. So let's get started. So we're first of all going to talk about the basics of how requests for production work. What is a request for production? Well, it can be a request to get certain documents or data or other physical evidence, the metaphorical smoking gun, so to speak, or it can be entry upon land. Let's say that there's a claim about damage to a house because of a faulty plumbing. Well, obviously the plumber who's being sued wants to have access to the house to inspect to see what other sources may have caused the damage to the house. So those are the kind of the two buckets that we're looking at when we talk about requests for production. I'll be honest, the more common way or the more common topic is going to be data or documents. That's where we're seeing most of the activity. And we're going to be talking about Federal Rule of Civil Procedure 34. So we'll be referencing that in several points during this presentation. So why do we care about documents and data and stuff? Well, this is oftentimes the key information that's going to decide whether we win or we lose the case. And we want to get what the other side knows so that we can be prepared for bad evidence and also reap the benefits of that good evidence. Probably it's difficult to think of any more important stuff that is in play in cases than requests for production. There isn't a lot of lawyering up you can do here like you can with interrogatories. I mean, you have to give up the stuff, and the stuff can oftentimes be really, really bad for you. I think all attorneys have had at times to pass over that smoking gun, that email that is just unexplainable in a way that you like at all. That's the nature of the beast, and those moments are very, very important litigation. Unlike interrogatories, requests for production can be sent to parties, of course. Well, of course, you can do that with interrogatories. But the difference is that they can also be sent to non-parties. I think the argument for the different treatment is that giving up stuff, giving up data is oftentimes less of a hassle than having to affirmatively go to the trouble of answering questions. And so that's the idea behind it. And that probably used to be pretty true. In a world with a lot of electronically stored data, it may no longer be true. Unlike interrogatories where there's a cap of 25 questions, there are no cap to requests for production unless there's some kind of local practice or rule that's that applies. And responses are not sworn. However, you do need to make sure that your responses are complete. You could be subject to sanctions if you did not fully respond to the questions. The responding party, the person who's receiving the interrogatories, only has to produce documents about which he controls. He doesn't have to, for example, subpoena other people to get those documents. The deadline is the same for requests for production as they are for interrogatories. It's 30 days from the date of service, or 33 days if they were mailed. Obviously, the parties can agree to a different timeline, and the party can approach the court if a different date is requested. Okay, so we have been charged with the task of preparing some requests for production. How do we go about that? What are the steps that we're likely to take? Well, the format is going to be very, very similar to the format that we use with interrogatories. We're going to have that same caption that we used for the complaint and the answer, for any motions and for our interrogatories. The caption won't change. We will also have some kind of section and some kind of very brief preamble. Those pretty much write themselves. You're probably going to use a canned preamble that you've used from previous documents. You'll need to have definitions and instructions. Again, very likely those will be boilerplate that you roll out from some other request for production that you used. And of course, at the end, we're going to have our subscription and our certificate of service. It's only in that middle area below the instructions that we'll be actually having new stuff. And even that really isn't that likely to be that new, because you're going to be reusing many of the requests for production that you used in past cases involving similar facts. And if you don't have that, then you may be going to some kind of forms manual of some type. You're going to want your request to be pretty specific, because if it isn't specific enough, the other side can object because it is vague, overly broad, unduly burdensome, something along those lines. So here's an example of one that is not sufficiently specific. A request to produce all documents relating to your negligence claim against plaintiff. Well, I mean, that could be all of your medical records, any kind of accident reports, any kind of repair reports, estimates, just so many different things could play in it. Maybe you ended up needing to go to a psychiatrist because of the stress, or you needed to go to a marriage counselor. Maybe you actually got it. I mean, there's just so many different things that can play into that. Too broad, it's too ripe for objection. So this one might be more in line with what you want to do. Produce all photos and videos depicting the damages to your vehicle that you are claiming in this lawsuit. Now, obviously, this is much cleaner, much more specific, much more particular, but you can see that you'll need to have many requests. And again, we're not under a maximum number, though, so there's really no reason why you won't want to break down your requests. And you'll obviously want to always go back and think, am I covering all of the territory, all the potential differing pieces of evidence that could be relevant to the case. Keep in mind also that many times requests for production marry up with interrogatories. So you might say, please produce all documents that you refer to in interrogatory 14, or something along those lines. You need to, in your request for production, discuss how you're going to inspect those documents, when, where, how. Again, we've already talked about the deadline. It's typically going to be at the end of the period of time. Often, your preference is going to be in your own office, and you can either have them organized in the way that the person who's producing the information would have ordinarily kept this information, or you can have it organized to respond to each particular request. Obviously, this one is probably going to be more to your liking. You cannot request that a party, and when I say a party, this doesn't have to be a party, but it could be a non-party. It does not request that a party or non-party create a document not already in existence. So if you are hoping that there's a table that describes this data, but it doesn't exist, you can probably get the raw data from the person to whom you are asking, but you'll have to prepare the table yourself. Of course, if the table does exist, you certainly can request it and get it at that time. Let's pause and talk a little bit about metadata. Metadata is really, really important. It's a strategic issue that you want to think carefully about. What data you want to get, what metadata is useful to you, what is not useful to you. You have to then consider, well, how are you going to unlock that data? Just a little bit of a refresher. Metadata is all the hidden data that is in a document. It's who created it, when it was created, how was it edited, who's seen it. All that stuff, if it's an electronic resource, is usually available. Of course, if the document is printed out, then all that data is not available anymore, and so the metadata can be very useful. On the other hand, if you happen to be getting 10,000 sheets of paper, each one having this metadata, it may be so overwhelming that you don't even know where to approach it, and so you have to consider, is the data going to be useful? And so there's all kinds of questions to think about along those lines. There are kind of two categories or two formats you might want to think about. One is we call a native format. This is how the person who is producing the document would ordinarily keep that data. For example, if it's a Word file, and that's how it was created and that's how it was distributed, well, then you might want the Word file. Usually, much of the metadata is going to be retained in that context. A static format is different. It's going to typically be a TIFF or a PDF format. The metadata has been lost at this point. It may be easier though for you to manipulate and use and access, and so can be advantages to both formats. If you are the person producing it, you're probably going to prefer the static format because you're giving up less information. On the other hand, it may take a lot of effort for you to convert from native format to static format, so you might want to consider the expense factor in making those changes as well. Obviously, the responding party can object and say that that's, overly burdensome if one format is requested over another format. This is the caption. It's no difference for this caption than the other captions we've dealt with in this course. Here's our Tyler document. We can see we have the 3 zones. So we've identified, first of all, who's sending it. There's only one defendant, so that's easy. And then this is the first one of this particular type of document. And finally, we have the name of the document. Then we have our to section. We're sending it directly to the attorneys, but we're going to say we're sending it to the plaintiff because we're actually metaphorically sending it to the plaintiff even though it's going to the attorney. Obviously, since Mr. Justice is represented, we can't send it directly to him. And then here we have this preamble where we've identified the rule. Defendant Burt D. Bandit serves these requests for reduction on plaintiff Buford D. Justice as authorized by Federal Rule Civil Procedure 34. Plaintiff must provide all requested documents, electronically stored information, or tangible things within 30 days after service of this request at the Office of Defendant's Counsel of Record, or alternatively another time and place agreed on by the parties. So very simple preamble. You can cut and paste this one a million different times. Obviously, you don't only want to use this in federal court, but other than that, it's good to go. And then here's an example of a signature block. No big surprises here. Again, we've talked about instructions in the past. You want to have instructions that are specific, but that are going to result in you getting as much data as possible. Here are some examples you might want to use. Respond to each request for production separately by listing the materials and by describing them as defined above. Okay, so we have our definitions before this in this particular wording. If the material is numbered or labeled for production, each response provide both the information that identifies the material and the material's number or label. We'll talk about bait stamping in a little bit. Produce documents and tangible things in the forms as they are kept in the ordinary course of business, or organize and number or label them to correspond with the categories in the discovery request. So in this situation, we're giving the option to the person who's responding to the request. And again, more specifics about how this will go on. This can go on for quite a while. And again, this is going to be boilerplate. You're not going to be rewriting this every time. You're going to read it over carefully before you send it to make sure the he should be he, the she should be she. All the specifics fit together, but you're probably not going to spend a ton of time with your instructions. And then here's definitions. We're going to be thinking about the same definitional things we talked about when we were thinking about the interrogatories. We want definitions that are very specific, but are going to also result in lots of data. So here we have an example, document. The term document, you can see it's in quotation marks, means information that is fixed in a tangible medium such as paper. It includes but is not limited to writings, drawings, films, charts, photographs, notices, memoranda, diaries, minutes, correspondence, books, journals, ledgers, reports, worksheets, notes, printed emails, letters, abstracts, audits, charts, checks, diagrams, drafts, instructions, lists, logs, resumes, and summaries. And again, now we have the ESI, electronically stored information. So we have a definition for that too. Especially this category does need to be updated periodically because there's always that new storage tool that is used that may not have been available once upon a time. And so you do have to think about updating this from time to time. And now we have the actual requests, and you can see we have some defined terms. Obviously, when you're producing this, you won't put them in red, but these are terms that are from our definitions. These are definitions that we actually presented in the interrogatories, and obviously the definitions you have here would include those definitions as well. It's perfectly fine. In fact, it's very common to use the same definitions in lots of different discovery tools. Let's just look at a couple so you can get a flavor for it. We've already, I think, done Number 1. Request 2, produce all police reports, including reports and any other reports by any governmental agency or official relating to the accident. Well, let's say you don't have any of these reports. You know that the police have them, but it's not your job to produce them unless you have custody of it. So your answer to this might be, I don't got it. Obviously, if you get it at some point, then you'd have to produce it. And you can see going through each one of these, it gives you more and more specifics to tick off as you are answering the questions. Now we're going to talk about when you're not sending these requests to a party. This is a non-party. And again, keep in mind, a party is either one of the plaintiffs or one of the defendants. A non-party is someone who is not actually suing or being sued. He's a witness in the case in some capacity. And I say witness kind of broadly because he may just have data. He may not have any first-hand knowledge. For example, you very likely will want medical records from the hospital. Well, the hospital people that the records custodian that you're approaching, I mean, he doesn't know anything about this case. You're just getting the records from him. Let's pause before we go any farther, and I know we haven't really talked yet about the rule. I always like to look at the rule before we go too far into the process. So I'm going to flip over here to Rule 34. This is the rule that's relevant to this type of discovery. And we have, first of all, we have a general section that kind of introduces you to the concept. Then we have the procedural section. And we have a section about non-parties. So let's look at the first section. In general, a party may serve on any other party. So now we're talking about parties here. And again, the scope is going to be the same as the general scope for any discovery. To produce and permit the requesting party or its representative to inspect, copy, test, or sample the following items: documents or ESI, or tangible stuff, or to put entry into designated land or other property possessed or controlled by the responding party, so the responding party may inspect, measure, survey, photograph, test, or sample the property or any designated object or operation on it. Okay, so this tells us what we have when we're requesting a discovery on a party. Let's look at the procedure we're going to follow. Oops. The request must describe with particularity. We've seen that word before, with particularity, so it needs to be precise. Each item or category of items to be inspected, and must specify a reasonable time, place, and manner for the inspection, and must specify the form or forms in which ESI is to be produced. You may recall we had a PowerPoint slide that talked about these specific things. Now we have to look at the responses. So this tells us what the request says. This tells us what the responses need to say. We've already talked about the time period. 30 days is the general rule. Again, possibly adding those 3 extra days depending upon how it's served on the respondent. And then responding to each request. Either comply with it, which is the first option, or you, with specificity, state your grounds for objecting to it. Then, of course, objections. When you are making an objection, you have to state whether there actually are documents or data or whatever that you are withholding because of the scope of your objection. And then let's look at the ESI part, electronically stored information part. The response may state an objection to a requested form for producing ESI. If the responding party objects to a requested form, or if no form was specified in the request, the party must state the form or forms it intends to use. Producing the documents or ESI, unless otherwise stipulated or ordered by the court, these procedures apply to producing documents or ESI. A party must produce documents as they are kept in the usual course of business, or must organize and label them to correspond to the categories in the request. If a request does not specify a form for producing ESI, a party must produce it in a form or form in which it is ordinarily maintained or in a reasonably usable form or forms, and a party does not need the same ESI in more than one, does not need to produce the same ESI in more than one form. So this is all the stuff that we've talked about with respect to parties. Now we're down here to non-parties. A non-party may be can be compelled to produce documents and tangible things or to permit an inspection. And you can see we don't have on that list ESI. Documents, let me just kind of piggyback here. You have documents, tangible stuff, or inspection. And up here we have documents, tangible stuff, and permit entry, which is inspection. We aren't seeing ESI on the list for non-parties. And that makes sense because they're so expensive and so burdensome. Okay, so let's go back to our slides. And now we're going to talk about preparing requests for a non-party. Typically, when you are going to request stuff from a non-party, you're going to be using a subpoena. What is a subpoena? Well, literally, it is, let me go ahead and flag it here so we can see the parts. Sub in Latin means under, and pena means penalty. So when you have a subpoena, it's a court order that says you are under the threat of a penalty if you don't comply with this. You are in contempt of court under those circumstances. So it is a court order compelling that non-party to appear, to give testimony, or in this case, this is what we're focusing on, to produce documents or other tangible stuff. And when you are producing stuff, we call it a subpoena ducis tecum. And it is a requiring that you appear and produce the stuff. Although I'll tell you, as a practical matter, you don't really care about the person showing up. You just care about the stuff. And ducis tecum in Latin means bring with you. A command in a subpoena to produce that stuff requires the recipient to inspect, copy, test, and sample the materials. There's a 3-step process. You're going to issue the subpoena ducis tecum. You are going to provide that subpoena ducis tecum to all of the parties in the case. Keep in mind the non-party who's going to get it, he's the intended recipient, isn't a party in the case. So you fill it out, you send it to everybody, and you also send it to the person who has to comply with it. So how do you actually get the subpoena to issue? Well, you go to that district court's website and look for the approved forms for different types of subpoena. And there's usually 2 ways that they issue. One is you can request that the court clerk issue a signed subpoena that is otherwise blank, and then the party goes ahead and completes it and then serves it upon the recipient. Alternatively, if the attorney is authorized to practice before the court, he is an officer of the court, and so he can sign the subpoena himself or herself, and that can function as a subpoena even without the court clerk's signature. What needs to be on the subpoena? Well, the name of the court from which is being issued, the style of the case and its cause number. Again, this is an opportunity for a person who wants to confirm that this is in fact an ongoing case, description of what needs to be produced, and if it commands the production of ESI, the subpoena can specify the forms in which ESI is to be produced. But keep in mind, it is not reasonable to request for a non-party to produce ESI the same way that a party might be required to produce ESI. Usually, in my experience, subpoenas ducis tecum require that the non-party provide the data to a court reporter's office who's designated. But it can be to the office of an attorney. And this is an example of what one might look like. So we have the style of the case, we have the name, we have who it's going to, and here is the stuff that is going to be produced. and we have it's going to be needs to sent to the court reporter's office at this time. And oftentimes what will happen is you will actually drop it off beforehand. It doesn't necessarily have to be at that particular time. And it's going to be signed, again, we can say it was signed by the clerk of the court, or in this case by an officer of the court who is admitted to practice in that particular court. And here's information about how Federal Rule of Civil Procedure 45 works. And again, we have to send this to the other parties so that they know what's going on. So how do we go about serving the subpoena? Well, it needs to be, a copy of it needs to be served on the person who's named. But if that person is not available, anyone who is over the age of 18, anyone can serve it. You don't need to be like a sheriff or a marshal or something to serve it. Anyone who's at least 18 is not a part of the suit may affect the service. And then the party needs to ensure that we have a sworn statement showing the date and manner of service, and it is sworn by the person who served it, that 18-plus-year-old. If the recipient doesn't comply with the subpoena, then of course that person is in contempt of court, and that person can be sanctioned by the court. So now we're flipping hats. Now we are the person who's receiving the request for production. Okay, so here's a 4-step process that you might look at. When you first get it, of course, the first thing you're going to do is you're going to calendar it. You're going to count, and whether it's 30 days or 33 days, whatever the period of time is, you're going to do the calculation. You're going to consider if the final day is a Saturday or a Sunday or a court holiday, and you're going to put that calendar date in. But of course, you're going to have several dates before then, because you can't just wake up that morning and say, okay, I'm going to start on this project that's due today. You are going to share those requests, of course, with the client, with the attorney. You're going to bring to the attention of the attorney and client any concerns that might exist. And then you're going to start drafting objections and responses to the various instructions, definitions, requests. And you are going to start finding and organizing the materials for production. In some cases, this might just take you 30 minutes to do. In some cases, it will take you, 300 hours to do. It's just such a variable in terms of the scope of the assignment. And then you're going to be preparing some kind of index to show all of the stuff that you've identified, what you've produced, what you haven't produced, if you haven't produced it, why you haven't produced it. So let's look at the stage 1. And that's here again, we're talking about this item right here. So you're going to calculate the date that it's due. You're going to put various reminders, hey, it's 10 days until we got to produce. Hey, it's 15 days until we have to produce. You're going to look to see what might be objectionable in it. And again, you'll have boilerplate objections that you'll be able to dust off and use. Obviously, you're going to want to talk to the supervising attorney about that. And you're going to want to talk to the client about figuring out what stuff is in the client's control. If your client is a human being, it's probably going to be pretty easy to figure out what he or she has. I mean, a person can only have so much paper. But if it's a corporation, there might be paper in all kinds of places, and ESI in so many places, that you really have to start really from day one trying to identify what you have and where you're going to find it. Responding to ESI in request for production is the most time-consuming part of the discovery process in many, many cases. And then you're going to start preparing the documents. You're going to prepare your objection and your responses. Again, you're going to be using that same caption that we've used again and again. And you'll have a title. And again, our order here is going to be those 3 things we've already talked about. We've identified who we are. There's only one plaintiff, so that's easy. And then this is our first set of objections with respect to this document, but we're not going to have others. I mean, this is going to be a complete response. So we're not going to say this is our first objections usually, although you could. and then we're just having the name of our response. Then we have who we're sending it to. Again, we're sending it to Bert D. Bandit, but we're not sending it directly to him because he's represented by Carrie Frog. So we're actually going to send it to Carrie Frog. And here we have our preamble. Plaintiff Buford T. Justice serves these objections and responses to defendant Bert D. Bandit's first request for production in accordance with Federal Rule of Civil Procedure 34. And we're going to have the same, of course it's going to go at the end of the document, but we're going to have the same subscription. And we're going to have our boilerplate objections that we're going to, obviously make sure are appropriate, but and some of these might involve some writing, but in many cases you'll have a set overly broad and unduly burdensome objection, another one about privilege that you can kind of just dust off and put into any response that is appropriate. Okay, so here are options for items that are requested. We can state that inspection will be permitted. That's, in other words, we're okay with that. We think it's reasonable and we think we need to comply with it. And so here we have that type of response. And you can say, just like we had with the interrogatories, we repeat the question verbatim. This again would be a good thing to ask a receptionist or secretary to type up. And then we have our response. All responsive photographs and videos are available for inspection and duplication in the Office of Plaintiff's Counsel upon reasonable notice. So we're saying we don't have any objections. We think this is reasonable. We also think that request 2 is reasonable. See attached documents, Bates stamped, Justice, and then document 6 through document 10. So we're saying this is all we have that's in response to this. We'll talk about Bates stamping in a couple minutes. Our second option, of course, is going to be to make specific objections and then to state whether we're withholding any documents on the basis of those exceptions. So we may think they're overly broad and unduly burdensome, so we're going to make that objection, then we're going to say what we're withholding, if anything. And so here's an example along this line. So we have our objection, now we're going to have our response. The objection is, plaintiff objects because the request is overbroad. Plaintiff is withholding responsive material on the basis of this objection. So there's stuff at issue here, and this might motivate the defendant to file a motion to compel or at least engage in some negotiation over this topic. Let's see what the response is. Subject to, without waiving the foregoing objective, plaintiff responds as follows. See attached documents, Bates stamps 11 through 16. And you can see in this example, the numbering is falling through. So we started, well, of course, we had 5 pages before this, 6 through 10. This is our next response, so not surprisingly, we're going to go from 11 to 16, and our next one is going to probably start at 17. Although, well, actually, it won't be starting at 17 because let's say we're withholding pages 17, 18, and 19. Well, then we'd start with number 20. Request, so we're going to gather that information from the client. You really, though, can't count on your client navigating through this system. You really have to be hands-on, helping them be aware of the scope of the request and what needs to be done. This is especially true if the client doesn't have a sophisticated legal department. Because at the end of the day, if they withhold stuff that they ought not have, and the court is obviously going to sanction them, but you, the law firm, could get sanctioned if it's obvious that you did not perform sufficient oversight. So it is very important that you hold the hand of the client through this document retrieval process and ESI retrieval process. Store the originals obtained for safekeeping to make sure that they aren't damaged or modified or destroyed or something like that. If it's not ESI, we're going to photocopy all the materials and keep them in some safe place that we've identified as the originals. If it's ESI, we're going to want to make an exact copy of that data and then have a working file where we can make changes, Bates stamp it, things along those lines. We want to keep one set of documents pristine and unsullied by the process. So we're going to have three buckets where we might have documents or data fit into. One is going to be responsive documents. These are things that we are going to produce that we think are responsive or answers or respond to the requests that are being made. Another would be non-responsive documents. These are things that we looked at, but we decided that it wasn't a fit with the request. And finally, are privileged documents. These are going to be responsive documents that we would ordinarily respond, but for the fact that they're privileged. And again, these can be documents, paper documents, but if it's ESI, we're going to have these same three buckets available. Okay, so we're going to sometimes need to edit responsive documents where you use the term redact, which means to redact means to cover up, obscure parts of the documents that aren't responsive and or that are not subject to discovery and or that are privileged. And so that process of identifying that and covering it up is oftentimes falls on the paralegal. Now, obviously, you want to work closely with the attorney to see whether, how much needs to be redacted, those specifics, but the mechanics of actually redacting it would commonly be something you would do. So you'd start with an original, but again, we don't want to do anything to the original that damages it or alters it forever. So we'll make a photocopy of the original. So now we're working with a copy, and then we're going to put redacting tape over it. And now we have a section of our document that's missing. We need to put some kind of stamp on it, though, so that the reader knows, hey, it's not just that this place was blank already. No, we've actually removed some material. You can't see stuff that was there. So this is, I guess, not sure why we're doing this twice. Oh, I guess another way of doing it would be to use black stuff, black tape. You can also use software. This is again useful for ESI. PDF documents, you can have redaction tools that will allow you to hide stuff, including metadata. Again, before you do these functions, you'll always be doing it to a copy. So if you make a mistake, it's okay. But you want to talk to the attorney to make sure you don't redact more than you need to, and then you have to restart. Okay, we've already talked about this, but there's two ways of kind of organizing the material. One is the way that it's ordinarily kept. So for example, let's say that there are some personnel files that are being produced. And the way that the questions were drafted were, we request all health insurance records, and then separately we request all disciplinary records regarding these particular employees. Well, it just so happens that this we'll say this isn't actually how it happened, but we'll just imagine that this particular employer keeps all of these healthcare records together with disciplinary records. And so they would then produce them the way that they store the data, which would be all of Bob's information, all of Sally's information, all of Teresa's information. Alternatively, the responder could group it in the same way that the request is drafted. So request one that has to do with healthcare information, all of Bob's and Teresa's and Sally's information together. All the information about disciplinary will have Bob and Teresa and Sally's information together. The downside to the first approach, well, the upside is that it's easier because you don't have to reorganize things. The downside is that because there isn't as much careful review, it's possible that things slip through that you really wish you hadn't produced or that you had been more aware of. Maybe there's some argument of privilege or some non-responsiveness or something along those lines. Option two takes quite a bit more time, so it's more expensive, but you're more likely to catch things that maybe shouldn't be produced. Now, sometimes you'll have attorneys who will claim, or not claim to the court, of course, but will talk a good game and say, well, we threw all the files up in the air and let the pieces fall where they may. The idea being, well, let's make them reconstruct the file, that they intentionally obfuscated the ordering of things. You're not supposed to do that. Now, obviously, you could argue, well, you know, we don't really have personnel files. We just randomly put pieces of paper in folders, and so Bob's records are commingled with Teresa's and Sally's and Harry's and Larry's. That's not very credible. And so, you know, you don't want to be caught intentionally doing that. The judge won't be very happy with those kind of shenanigans. So it's time to produce the documents. You have a couple of approaches. One is to send the copies to the attorney for the side requesting it. This is commonly done when it's not a huge amount. I mean, the alternative is to say, come and look at the files and photocopy it yourself if you want to. If you do that, though, whenever they come and look, you're going to have somebody be there to supervise them. And so it's actually easier for you and easier for them if you choose this option. The only time you're not going to want to do it is if it's so much paper that it really would be expensive to go ahead and do that. And of course, you could handle it some other way. The parties can negotiate amongst themselves to come up with an organization system that makes more sense. Okay, now we're up to Bates stamping or Bates numbering. I guess Bates stamping is probably a bit of an old-fashioned term. Back in the day, paralegals would have a stamp, and as soon as you push down, it would leave a number, and typically it would be a 6 or 7 digit number. And then the next time it's stamped down, it would automatically advance. So stamp 1, so stamp 8, stamp 9, stamp 10, stamp 11, stamp 12, and so on. You didn't have to individually advance it. I don't know who Mr. Bates or Miss Bates was, but for whatever reason, they got this name. Nowadays, yes, there are still times where you have to Bates stamp. You actually have the stamper, but there's also computer-generated labels and machines. Photocopy machines will do it. There's lots of newfangled ways of doing it that makes life a little bit easier, but that's when people talk about Bates stamping, that's what they're talking about. And typically you're going to have a relatively long digit. You're probably not going to get up to the 100,000s, but you're going to use that same Bates stamping software and machine for small cases and big cases, so there's no reason not to use a lot of digits. You're going to try to put the Bates numbering in the same location, and it's designed to be fairly distinctive looking. And so why are you doing this? Well, this is a way of making sure that you get all of the sheets of paper. So if you just advance here. Here we go. So let's say you decide that this page 4 is privileged. Well, the other side is going to get BTJ00003 and BTJ00005, but they're not going to get this page. And they can see they didn't get it because of the fact that they can see the sequential numbering. So it's a way for both sides to know, hey, we gave you everything we were supposed to, and yep, we got everything that we were supposed to. So there can't be a claim of, you didn't give me that piece of that document. Well, yes, I did. Well, no, you didn't. Well, yes, I did. I mean, how can you prove that? Well, Bates numbering allows the parties to confirm that. And so let's say I get I'm the recipient of the request for production data, and I go through it and I'm looking for numbers, and if it says I'm supposed to have 00008 through 00011 and I don't see 00010, well, I'm going to call up the attorney or the paralegal and say, hey, I'm missing 00010, please send me another copy of it. It allows both parties to be 100% sure that all the photocopying was handled appropriately. Because, I mean, there can be problems. There can be inadvertent errors along the line, and this is kind of an insurance policy for that. So we also need to think about a privilege log. Many of these cases will have some privilege documents that we aren't going to be giving up, and we've talked about this before, but we want to, again, look at what a privilege log looks like. Again, it's going to have that same caption. It's going to have a name with the 3 parts. Actually, in this case, we have the name of the plaintiff. We really wouldn't have to have this part because there's only one plaintiff. Then we have privilege log, and we might specify in a little bit more detail because he might have more than one privilege log that comes up. For example, this first privilege log, well, I suppose you could have a privilege log that evolves over time, that it gets bigger and bigger, but you might have a privilege log with respect to a particular set of interrogatories or a particular set of requests for production. So I could see that going either way. In this case, they aren't is numbered. They're not identified to a particular discovery tool. Here we go. And so here's an example. You need to provide, of course, we have the 2-line. This is, you're sending this to opposing counsel, and this is your privilege log. And you can see we have our Bates numbers. We have the date that this particular thing was created. We have what type of discovery it is, what is its format, who wrote it, who received it. And this, of course, is really, these two are really important. What is the subject, and what is the nature of the privilege? The nature of the privilege is going to be attorney-client or attorney-work product, so that's not going to be especially surprising. But you needs to be specific enough so that the parties can, so that the person who is receiving the privilege log from the other side can look at it and say, yeah, that's something I want to challenge. I'm not sure I think that's privileged. But not so specific that you're waiving the privilege, because obviously if you start quoting from the document, you waive the privilege. So this is an example of how that document might look. And again, you're going to close with a subscription. And you're going to have a certificate of service. You're going to want to obviously keep your own set of the Bates numbered files so that you'll have a record of what exactly was produced if there's any dispute. And you're going to have a cover letter. You're going to list exactly what you're enclosing in terms of the Bates numbers, and obviously there may be some gaps. Those will be for the privilege log. And you're going to describe what those documents are. You're going to have an index of all the documents produced, including the Bates numbering, the date of the document, all that information that we have on the privilege log, but that would be for all the documents that are produced as well. Again, the format of this might vary from firm to firm. So now you earlier, I guess about a month ago, you made a request for production. The other side has been working fast and furious for the last month on getting you those documents, and you've finally gotten the stuff from the other side. So you're going to want to look it over immediately to see where are the gaps, what have they not given up, and what are their objections, and how might it be approached. And obviously you'll want to talk to opposing counsel. Opposing counsel may want to contact the attorneys for the other side and challenge some of the objections or the level of compliance with discovery. And if the parties can't reach an agreement, there may need to be a motion to compel. In order to file a motion to compel, obviously there's going to have to be a certificate of conference saying, hey, we tried to negotiate this, we tried to work it out, we weren't able to be successful. And then the motion to compel will be presented before a judge, could be the federal judge, or it could be a U.S. magistrate judge. And then that judge will decide whether the motion to compel ought to be granted. If it's granted, it's likely there will be a level of sanction. It may just be the costs of filing the motion to compel. On the other hand, the motion to compel may be denied. It may be that the opinion of the magistrate is that the objections were valid ones. Hope you found this discussion interesting and helpful. If you have any questions, please bring them to class. I'll be glad to share or discuss these in more detail and answer any questions that you have. Thank you for your time and your attention.